have to fear is
In war, there is no substitute for victory.
Let us never negotiate out of fear.
We stand undivided, forever united, fighting hand in hand for the liberty we burn, for glory and honor, for our sons and daughters, ever mindful of the lessons we've learned. Let the torch of freedom burn.
Welcome to the intersection of faith and politics. This is WallBuilders Live. Thanks for joining us today. Visit online at wallbuilders.com and wallbuilderslive.com. There at our website at WallBuilders Live, you can get a list of all of our stations. You can get our archives. And by the way, if you'd like to email us, maybe there's a topic you'd like us to cover or a guest you'd like us to have on or a question you have. And we love your questions about the Constitution, by the way, and the Declaration and founding principles. We love covering those on our Thursdays for Foundations of Freedom Thursday. But any questions you got, send them to radio@wallbuilders.com. I'm Rick Green here with David Barton. David, we've got a Supreme Court case that you've been looking forward to finding out how it was going to turn out for quite a while.
Yeah, I have been, and it was a scary case. If you look, and it dealt with public prayer in America, whether you can have public prayer, public bodies. And if you look at America from the very first, when the first folks landed here, officially that government-sent group got out, and what they did at Cape Henry was kneel down and have a prayer service. The next big group that got here, the Pilgrims, again, government charter, they're coming here. They get out of the boats and they kneel down and have a prayer service. And it was that way when the settlers came to Maryland, sent by the government, they get out and kneel down and have a prayer service. And you find that throughout. As a matter of fact, when you have your first legislature elected in America, 1619 in Jamestown, they had a prayer service. Actually, the legislature itself met inside the Jamestown church, and the legislators sat in the choir loft of the church. So from the very beginning, prayer has always been a part of our government functions and government bodies. It was that way even in Washington's inauguration. There were 7 religious activities in Washington's inauguration, and 4 of them involved prayer. So there's George Washington, the father of the country, the president of the convention who just gave us the Constitution, and 4 of the 7 activities in his inauguration involved public prayer. So obviously this is something we've had from the beginning. By the time you get to 1815, there have been 1,400 government-issued calls to prayer in America, public prayer.
Wait. Just to clarify here, 1,400.
By the government.
Not just 1 or 2. Not just, that was that George Washington guy.
No.
1,400.
By 1,400 government-issued proclamations. And by the way, we have hundreds of those listed on our website at wallbuilders.com because we actually don't just list the proclamation. We show you the actual proclamation itself. We own so many of those proclamations. So the calls to prayer and praying in public prayer, really, really, really part of America. Well, we had setbacks on that in a number of occasions. We had a case in 1992, Lee versus Wiseman, a case in which I got to be involved at the Supreme Court with amicus and getting to do the historical stuff and write the historical stuff to offer the court. And at that point, the court said, whoa, we got a public prayer going here. It involves a school graduation, and we've had those all the way through. As a matter of fact, part of what we showed the Supreme Court was founding fathers who signed the Constitution who did prayers at graduations in their days and even quoted scriptures and gave sermons at graduation in their days. And yet the Supreme Court said, no, we're not going to do that. We can't let that happen in schools anymore. Well, that limited schools, but suddenly that opened the door for all these suits to be brought against cities and city councils and other bodies, state legislatures who opened with prayer. And so even though the Supreme Court in Marsh Chambers in 1984-85 said, well, it's okay if it's traditionally historical for legislative bodies to open with prayer, you can do that, they started whacking away at schools in 92. And so what it led to was the decision in the last 3-4 years coming through New York that said, well, the town of Greece, they've got this situation where they open their city council with the prayer, but because some of the guys used the word Jesus when they prayed, you can't do that. And so lower court struck that down. That worked all the way to the Supreme Court, whether the question was going to be, can somebody acknowledge God in a public prayer? And if they do acknowledge God, can they actually pray what they want to pray in the prayer, or does the state have to tell them what to pray? In other words, if a minister wants to close with Jesus in the prayer, can he do that, or does he have to pray only what the state tells him he can pray? And that was the question before the U.S. Supreme Court. Now,
and that's kind of like that judge in Texas years ago that told that girl, you can pray, but you got to pray the way I tell you to pray.
That's
you can't
right.
mention Jesus. Yeah.
And he had that judge, Samuel Kent, I have his decision, actually said, I'm going to have a U.S. Marshal listen to your prayers. And if he hears you pray a wrong word, you will spend 6 months incarceration in the Galveston County Jail. And so I'm going to have the federal government listen to your prayers, and if you choose the wrong words, you will go to jail over this. Well, that's the kind of mentality that's been growing over this period of time. Now, what happens is we end up winning this case at the Supreme Court. We win it by a 5-4 decision, which is in itself scary. But what's really ironic here is in 1992, when the court struck down the public prayer then at school, it was Justice Kennedy who was on the wrong side of that and introduced actually what's called the psychological coercion test, where it says, we had 2 people at that school event that were atheists, and Rabbi Gutterman, who did not pray in Jesus' name, he just mentioned the word God, but those 2 atheists objected to hearing the word God, and Kennedy says, well, yeah, that is psychological coercion. To be forced to listen to the word God when you're an atheist, that's coercion. And so the court introduced a psychological coercion test, which over years has developed in what we call the constitutional right not to be offended, or the heckler's veto, that all I have to do is say, hey, I feel like an outsider. Somebody said, God, I'm offended. Make them all stop. It was actually Kennedy this time who changed his own position from 20 years ago and said, you know what? It's time for America to grow up. Just because you get offended doesn't mean you have a constitutional right not to hear something. And he actually went so far as to say, you know what? If the test invented by the court strikes down what the Founding Fathers themselves were doing, then the test is wrong, not the Founding Fathers. That's a repudiation of what he said 20 years ago as well. So this is a huge victory because, had it been up to Kennedy and where he was 20 years ago, we would not be allowed to mention God publicly today. Had this decision gone the wrong way, and it almost did, 5-4. And if Kennedy,
it sounds like he chastised himself.
He chastised himself.
Like this resurgence of interest in the Founding Fathers and the Constitution and original intent has allowed even a Supreme Court justice to learn and correct himself.
And anybody who thinks I don't believe in evolution is wrong. I've just seen it with Justice Kennedy. All I have to do is look at Justice Kennedy. He's evolved over time. And this is unfortunate because the Constitution has not evolved. It should have been the same thing all the way through. He got it right this time on original intent, and he talked about original intent. And so that's the good news. And one of those folks who was involved in helping get all this set up and done was Liberty Counsel. And so we thought, since they were right there in the court with all this stuff going on, they'd be a good one to kind of give us their views on what they see from this decision.
Justin Butterfield is a senior counsel from Liberty Institute. He'll be with us when we return right here on WallBuilders Live.
This is David Barton with another moment from America's history. Although education has remained an emphasis in America for nearly 200 years, what has changed the most over that period of time is the philosophy of education. For example, while religion finds no place of refuge in our schools today, such was not the case at the time of our Founding Fathers. In fact, when the Delaware Indian chiefs brought their youth to be trained in America's schools, on June the 12th, 1779, George Washington told them, "You do well to wish to learn our arts and our way of life, and above all, the religion of Jesus Christ. These will make you a greater and happier people than you are. Congress will do everything they can to assist you in this wise intention." According to George Washington, what students learned above all in American education at the time of the Founding Fathers was the religion of Jesus Christ.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom burn.
Welcome back to the intersection of faith and politics. This is WallBuilders Live. Thanks for staying with us. Our guest today, Justin Butterfield. He's Senior Counsel and Director of Research and Education at Liberty Institute. Justin, good to have you on, sir.
Thanks for having me.
Hey, appreciate all that you guys do, and a lot of great victories out there that have happened in the last year or two, thanks to Liberty Institute. Can you give us y'all's website before we jump into today's case?
Sure. Our website, where you can find out more about us, is www.libertyinstitute.org.
Excellent. All right, so this case, a lot of talk recently over prayer at a governmental meeting. Supreme Court case, great victory. Tell us about it.
That's right. So it's a case in the town of Greece, New York. where a town council opened with prayer. Now, as you and I'm sure your listeners are aware, this country has had a long tradition of opening governmental meetings with prayer. You know, the first Congress opened with prayer and, in fact, hired a full-time chaplain to open congressional meetings with prayer. And this happened within 3 days of their passing the First Amendment to the Bill of Rights. So they clearly understood that having a congressional prayer, opening government meetings in prayer, is constitutional, fully comports with the Establishment Clause.
Yeah, so what a great example if it's the guys that gave us the First Amendment. I mean, clearly their original intent of that amendment and that language and our protection of religious liberty and the others in there, clearly they understood that having a prayer, even at a governmental function, is not in any way a violation of that. I mean, if they set the example for it, I don't even see how the other side on this issue even makes an argument with a straight face that it would be unconstitutional if the guys that gave us the Constitution did it.
That's exactly right. And there's a long-standing tradition that the Supreme Court has held that whatever the first Congress does or did is presumptively constitutional. That is, the people who passed the Constitution, enacted the Constitution, probably knew what the Constitution meant, and so what they did likely was constitutional.
Yeah, I would think so, and because there's no amendment to the Constitution since that time that even comes close to touching this issue.
That's exactly right.
All right, so apparently, I guess someone must have sued them for praying. One of these organizations that just gets all bent out of shape if anybody actually expresses their faith.
Yeah, there were actually two members of the community who filed a lawsuit saying that opening the town's meetings with prayer offended them, and the Supreme Court took the case after the Second Circuit actually agreed with these two people and said that opening this town council meeting with prayer violated the Constitution.
So you guys actually went into the Supreme Court case basically having to come back from defeat, right? I mean, if the Second Circuit said, no, you can't pray, you guys went in having to get that overturned.
That's exactly right.
All right, so did you guys, I'm curious about what was going on behind the scenes with you and Kelly and everybody else there at Liberty. How did y'all feel about it going in before you actually made the arguments and even after that, before you got the decision? Were y'all confident or were you worried? I mean, because this would have had, well, it has huge implications one way or the other on the whole country.
You know, we were confident, and we filed an amicus brief in this case representing a group of theologians, and there are some particulars of this case that were really of interest to us. And so we were confident that overall we were going to win. The issue was how we were going to win, I think. So a little bit of historical background. About 30 years ago, in a case called Marsh versus Chambers, the Supreme Court held that legislative prayer is okay. That is, this kind of opening town council meetings, state legislative meetings, Congress with prayer is perfectly acceptable. And the Supreme Court recognized that going back to the history of the United States. The issue was, in some later Supreme Court cases, there was some dicta, that is, some language not in the holding of the case, but just the justices thinking out loud in their opinions, that said, well, we agree that historically this has been done, but we don't know if it can be explicitly Christian prayers. And so the real issue in this case, in Galloway versus Town of Greece, was what does that mean? Can we have any kind of opening prayer? Does it have to be this religious neutral? We'll have a civic religion. We'll pray to a generic God, but you can't say Jesus. You can't pray to the God that you actually believe in. It just has to be this generic God that everybody can tolerate. And so that was really the key issue in this: is how much freedom to pray do you have?
Yeah, is it a freedom for you to pray as you wish, or is it going to be a government outlined and controlled prayer?
That's exactly right. And so in this case, our amicus brief argued that if you require this civic religion, a generic God that everybody can sort of tolerate but nobody has any real connection to, that is actually a violation of the Establishment Clause. That's the government saying, this is the state religion. You can pray to generic God, but you can't pray to Jesus. You can pray to generic God, but you can't say anything that somebody else might disagree with. And that is the definition of an establishment of religion. The government saying, this is the favored religion. You can pray to this God, but you can't pray to any others. And that's a real problem. So our amicus brief, on behalf of several major theologians, argued that you can't even do that. If you create a civic religion, you are there is no such thing as a generic God that everybody can tolerate. It's always going to cause a problem for somebody, for some religion. And so the best thing for the government to do is to say whoever is giving the prayer, they can give that according to their conscience. The government has to stay out. The government can't endorse certain religious viewpoints, can't endorse this generic civic religion, but instead just should let each person pray according to their conscience.
Complete freedom for the person that's actually got the microphone and been chosen to pray.
That's exactly right. And thankfully, that is what the Supreme Court went with. They said that it would be a violation of the Establishment Clause for the government to endorse certain religious beliefs or to limit people to only praying to this generic God. And so the correct analysis is for each person who prays to be able to pray according to their conscience. So that's a great victory.
It is a huge victory. Justin, got to take a quick break. We'll come back and ask you, what do you think the impact will be here? How does this play out across the country? And kind of your response to some of these headlines I saw that said, oh, religious liberty takes a blow. It was a loss for religious liberty. I'm lost at the logic of some on the left whenever religious liberty wins and they say that we've lost. But we'll be back in a moment. Stay with us right here on WallBuilders Live.
This is David Barton with another moment from America's history. Federal courts have made several amazing rulings recently, ordering the removal of a cross from a cemetery, banning religious holiday displays, removing the Ten Commandments from public view, prohibiting student prayers whether verbal or silent, and numerous other similar restrictive rulings. As one current justice has noted, the Supreme Court has now become, quote, a national board of theology. Our founding fathers would be astounded. They designed the First Amendment to keep the federal courts completely out of this issue. As Thomas Jefferson forcefully declared, I consider the federal government as prohibited by the Constitution from meddling with religious exercises. The First Amendment was designed to keep decisions on religious expression out of the federal courts and in the hands of the local communities.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom
Welcome back. Thanks for staying with us here on WallBuilders Live. Justin Butterfield with us from Liberty Institute, their website, libertyinstitute.org. So many cases that they're dealing with across the country, whether it's the famous cases trying to get rid of crosses, or in this case, dealing with prayer at a public gathering or a government. What do you even call that, Justin? How do you put all of the different? Because I'm thinking about school board meetings. I'm thinking about commissioners' meetings. Even a National Day of Prayer, some people would challenge as a government meeting. What was the language y'all used for that to kind of get a catch-all for all these different kinds of meetings?
So usually they're referred to as legislative prayer. Now, obviously, some of those, like you mentioned, the National Day of Prayer is not necessarily legislative, but the vast majority of these meetings are in front of legislative bodies, state legislatures, Congress, town council meetings, all having some sort of legislative role.
So let's go to what we talked about before the break. That is kind of the impact nationally, because weren't there several cases in the last few years where actual legislatures had been slapped down, sometimes by state courts, but told that they couldn't even have a prayer in their legislature? I think it was Indiana or a couple other places like that where there was, in fact, not only some told they couldn't pray, but told you could not pray in Jesus' name if you do pray, kind of like what you were talking about earlier. It had to be generic.
That's right. So the Supreme Court was pretty clear that legislative prayer as a concept is allowed. The issue really came up with what are the limits of that. Like I mentioned earlier, there were some courts who said, well, you can pray, but you just can't pray in Jesus' name. You can't be explicit about your prayers. And so that's really where the debate has been for the past 30 years is, can you pray according to your conscience, or do you have to give a generic watered-down prayer? And so that's really the type of case that this recent case of Galloway versus Greece dealt with, is the Supreme Court said, we've already acknowledged that you can pray, but now here's how you can pray. You don't have to give these watered-down prayers. And so it effectively reverses any decision that said that, you can only give watered-down prayers to a generic civic religion God instead of to the God that you believe in.
So was there any kind of and I have to admit I haven't read the decision, so was there any kind of a test type deal like when Sandra Day O'Connor was on the court, she'd always come up with these 3-part, 5-part tests that made it very complicated on what was allowed and what wasn't allowed. Did they do that in this case, or is this a pretty clear blanket, hey, if you're invited to pray before a government function, you've got the floor?
It's actually really interesting. They didn't really resort to a test. The classic test for Establishment Clause cases is called the Lemon test, which has been around for a long time. And as Justice Scalia says, it's like a ghoul that the Supreme Court keeps trying to kill, but then when somebody wants to strike something down, it rises back from the dead to come and strike down that action. In this case, they did not use the Lemon test. If they used any test at all, you would say they used the Marsh test, which is the 30-year-old case saying that, well, we should look back to the history in the United States, and the first Congress had chaplains, and what they did was presumptively constitutional because, they hired a chaplain within 3 days of enacting the First Amendment, so they probably knew what the First Amendment meant, and this probably doesn't violate it.
So they really went to the heart of the amicus brief you guys filed then. It was a really good historical opinion. It's the way a lot of times it's what we wish the Supreme Court would do, look at what the actual history, what the actual intent of the founders was, and apply that. And that's really what they did in this case. Instead of using, a new test that was developed in the past 20 years, they went back to history, went back to the founders, and said, okay, what did the founders think about this? What did the people who passed the First Amendment think about this? And what would they say? And they said clearly they believed that this sort of prayer opportunity was perfectly constitutional, perfectly fine, and they went with that. That in and of itself, Justin, is huge. I mean, not only the victory on the facts here, but the process and the thinking and the reasons for it. I remember I guess it was 2 years ago, Ted Cruz gave a speech before the Federalist Society right after he had won his election, and that was exactly what he talked about. He said, if you think about it, 20 years ago, no one was even making the argument. The court was not even talking about or debating in their opinions what the founders thought or what the original language said or what the original intent was. It was just all about pontificating over what one judge said, last year or 10 years ago. It was all about what the court had said and not what the original intent was. And he was talking about the need to get back to that. And here we are just 2 years later, a landmark Supreme Court decision that you said is doing exactly that, is going back to the original intent. That's a hallelujah right there.
It definitely is. We've come a long way from the time when Rehnquist was the sole justice on the Supreme Court who cared at all about history or cared at all about what the original intent was. And, we've really gone from him being the lone voice crying for us to consider what the actual intent was, to where that is now at a position that the Supreme Court, a majority of the Supreme Court, was able to go with. And so it is a really huge victory, a really great indication of how things are going in this area of the law.
That's fantastic. Well, Justin, we appreciate it, man. We really, honestly, I don't believe these things would be happening, these victories wouldn't be happening if it wasn't for organizations like Liberty. We appreciate you guys so much. Encourage people to visit your website at libertyinstitute.org, contribute, get on the email list, follow these cases. This is one of many that you guys are fighting, and we definitely appreciate your time, taking time out of your schedule to come share with our listeners an update on this case. Thanks for being on, man.
Well, thank you for having me.
Stay with us, folks. Back in a moment with David Barton.
Hey guys, this is Tim Barton with WallBuilders, and I know you hear my dad and Rick talk a lot about our founding fathers, about the original intent of our nation, the constitutional heritage that we have, and really we've seen how far we've slipped away from that. And I know a lot of us, as we hear my dad and Rick talk, think, I wish there was a place that I could go and I could see these documents, that I could read and learn about the founding fathers firsthand, see the things they did. And I want to give you some websites today that can help you accomplish that very thing. If you get online, you can go to places like Library of Congress, and you can look under their Century of Lawmaking or historical documents. You can go to the Avalon Project, to the Founders Constitution, to Google Books, or even the Internet Archives, or you can just go to WallBuilders' website. We have a section for our library, and under that section we have different subgroups for historical documents, historical writings, even a place where you can get helpful links to find out more information about other websites where you can do research for yourself and find the truth for yourself. Friends, this is a time that we need to know who we are and where we came from. WallBuilders.com is a great place to go.
Welcome back. We're back here with David Barton now. Thanks for staying with us here on Wall Builders Live. I love, David, just the fact that, man, this speaks well for the future in terms of finally getting the justices to even think about original intent and what the founders actually said. You remember the One Nation Under God case with the flag in the Ninth Circuit?
Yeah.
They didn't quote anything from the founding fathers,
Yeah.
even refer to the Constitution. So this is a big step in the right direction. You've been trying to get this done for 25 years, so you got to be pretty excited about this.
Well, there were three things I thought were really good. One is they went back to original intent, which is where they should have been. So we're getting back to that. The second thing is this should really emasculate groups like Freedom from Religion Foundation. We've seen in the last couple of years they have just about terrorized states like North Carolina, sending them letters saying you can't have prayer in city councils. Man, that's going to put an end to that. But the third thing that I really liked, and it really ticked me off for years, was they kept allowing us to use God in prayer because they said, well, it's ceremonial deism. You know, nobody really believes it. In God we trust on the money, or under God in the pledge. You can do it because it's ceremonial deism. Wait a minute. You're telling me that I don't really believe in God and that you're telling me what I believe about God? Well, this knocks that down because this is not, when you're using in Jesus' name in a prayer, that's not ceremonial deism. And for the court to recognize that you have a right to have your religious faith and express that faith even in public, that's a huge, huge, huge victory. So, you know, even though it took this evolution of Kennedy to get us here, it's definitely a step back toward original intent and toward religious freedoms for all Americans, and this is good stuff.
Very, very exciting. A great victory. We're thrilled about it, and it's going to have a huge impact for years to come. Thanks for listening today to Wall Builders Live.
We stand undivided.